All right, Joan, you're on mute.
Okay. Welcome to the League of Women Voters of Wisconsin's third webinar in our issues briefing on the constitutional crisis. We have now heard two excellent presentations on the crisis in the executive branch and the legislative branch. It's now time to hear about the third branch, Article 3. So many of you had questions during the first two webinars about the Supreme Court. Our speaker tonight is the perfect person to discuss the crisis in the current Supreme Court and its increasing use of emergency orders, more commonly known as the shadow docket. Stephen Vladeck graduated from Yale Law School in 2004, where he was executive editor of the Yale Law Journal. After law school, he clerked for the Honorable Marcia Berzin on the U.S. Court of Appeals for the Ninth Circuit and the Honorable Rosemary Barkett on the U.S. Court of Appeals for the 11th Circuit. He is a professor of law at the Georgetown University Law Center, is a nationally recognized expert on the federal courts, national security law, and military justice. He is also a highly regarded appellate advocate, having argued before the U.S. Supreme Court and numerous other lower federal civil and military courts. He authored the book, quote, The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, which has won numerous awards. He has also received numerous awards for his influential and widely edited legal scholarship, his prolific popular writing, his teaching, and his service to the legal profession, including the 2024 University of Texas President's Research Impact Award and his selection by the Order of the Coif to serve as its distinguished visiting professor for 2025. Professor Vladeck is CNN's Supreme Court analyst and editor and author of One First, a popular weekly newsletter about the Supreme Court, which I encourage you to subscribe to keep up with the Supreme Court's orders and decisions. A forthcoming publication from Professor Vladeck is entitled Fixing the Supreme Court Through Its Docket. We are extremely honored to have such a nationwide and highly credentialed speaker today for our webinar on the Supreme Court and the shadow docket. Thank you, Professor Vladeck.
Thank you, Joan. Thanks, Brandy, and everyone at the League of Women Voters. It is a real treat to get to spend some time with all of you tonight. I wish it were under better circumstances, but if it were, you wouldn't probably have invited me. So one of the problems with the work I do is that it has become, unfortunately, very important. I have a slideshow, which I am going to share in the Zoom, and which we're also happy to make available to folks offline. Just gonna be 1 second to pull it up. Hopefully everyone in a second will be able to see the slideshow. And so my plan for this evening is to give probably about a sort of an opening presentation of somewhere between 45 minutes and an hour, and then leave time for your questions and our discussion at the end. So please do ask questions. So here's where I want to start. I want to start with the term shadow docket, what it means, where it came from, and what it really conveys. So when we talk about the Supreme Court of the United States, historically, we tend to be focused on what law professor nerds like me might call the merits docket. That is to say, the 60 or so big decisions that the Supreme Court hands down after multiple rounds of briefing, after oral arguments each term. Well, the shadow docket is really everything else. And it's a term that was coined by University of Chicago law professor Will Bode in 2015. And Will really meant it as a descriptive shorthand, not necessarily pejorative, but just to try to capture the reality that most of what the Supreme Court is actually doing on a daily basis is not the stuff we see in those merits decisions at the end of the term, that the Supreme Court actually is handing down hundreds, if not thousands, of significant rulings every year. We just tend not to notice them because they are orders, not usually opinions. And so this is from Will's 2015 op-ed where he introduces the term. And so the idea behind the term shadow docket was not that there was anything necessarily nefarious happening in the space, but that just this stuff isn't stuff that we spend a lot of time talking about, that it's literally in the shadows, in that some of it happens at night, that it's figuratively in the shadows, in that these orders are often unsigned and unexplained. And so Will's thesis was that we should pay more attention to what the Supreme Court's doing in the shadows. That was 10 years ago now. Well, I think it's safe to say the term and the court's behavior on the shadow docket have become a lightning rod. Since the mid 2010s, the court has used the shadow docket to a much more significant quantitative and qualitative extent than we've ever seen before. And so some of that has been through what's called the certiorari process. Certiorari is the process by which the Supreme Court decides which cases it's going to take up on the merits docket. And that whole process is cloaked in a lot of, sort of norms and expert understandings, but not a lot of publicly accessible conduct. And so one example of massively important rulings through cert denials, through the Supreme Court not taking up cases, actually came in 2014 with regard to same-sex marriage. I think most of us tend to associate same-sex marriage with the Supreme Court's 2015 ruling in Obergefell. It turns out that by the time the Supreme Court decided Obergefell in 2015, it had legalized, either courts or states had legalized same-sex marriage in 37 states. Obergefell only legalized same-sex marriage in 13. 19 states had legalized same-sex marriage on their own. Another 18 had had lower court rulings blocking their same-sex marriage bans, appealed to the Supreme Court, and then the Supreme Court denied cert. And so it was those cert denials that actually led directly to same-sex marriage in 18 states in 2014. That's not especially controversial. It's just here as a placeholder to show you that even when the court does something we tend to think of as administrative, as denying cert, it can have massive real-world effects. But the real shift has been on a particular slice of the shadow docket, and that's with regard to what the lawyers call emergency applications, applications for emergency relief, which have really both skyrocketed in number and in importance over the last decade. And I think a lot of folks first really became aware of this phenomenon back in 2021, when 9 months before the Dobbs decision, the Supreme Court effectively allowed Texas to ban abortion on a statewide basis through an emergency application. So what does that mean? I mean, I know a lot of us are not lawyers. What is emergency relief? Here's how I like to think about it. So the typical lawsuit takes years, 1 year, 2 years, 3 years, sometimes 6 years to work its way from when it's first filed in a state or federal trial court all the way to a final ruling, whether it's in a state Supreme Court or the US Supreme Court. That's a lot of time. And often there's a significant question, especially if the lawsuit is challenging ongoing, say, government action. There's a really important question about what the status quo should be during that time. If it's going to take 3, 4, 5 years for a case to get all the way to the Supreme Court, in the interim, should the challenged policy be blocked, or should it be allowed to continue into effect? This is often dealt with, right, at first at the trial court. A trial court will be asked to issue a temporary restraining order or a preliminary injunction to basically sort of set the status quo at the beginning of the case. But even if the trial court rules one way, what we call emergency relief is when whoever lost in the trial court doesn't just appeal, but asks the appeals court to change the status quo for the duration of the appeal. So just take the Trump cases, right? So a trial court blocks some policy of the Trump administration. The Trump administration wants to appeal that decision, but they also want the policy to go back into effect while they're appealing. That's emergency relief, right? An emergency application is, we want you to pause the effects of the lower court ruling for however long it takes us to appeal it, for however long it takes you, the appeals court, to decide whether it was right or wrong. And so those are emergency applications. And the norm is that you ask the intermediate court of appeals first. So in federal court in Wisconsin, that would be the Seventh Circuit, and then the Supreme Court. That's how emergency relief has always been understood. It has been, I think we can say, a sort of regular part of federal civil litigation since at least the turn of the 20th century. So for about 125 years now. But if it's been part of federal civil litigation for so long, what's the problem? Well, there's nothing inherently pernicious about emergency relief. We can all think of cases where it's necessary and or appropriate, right? Where, the trial court did something that we think is radically wrong, and we shouldn't have to wait 2 or 3 years for the effects of that decision to be halted. But historically, and this is where I really want to sort of spend a minute on the history, the US Supreme Court took a very, I think, clever approach to how it handled emergency applications. And the basic approach the Supreme Court took, really from the early 1900s until the 1980s, was to have all emergency applications funneled to, and not through, but to the designated circuit justice. So everywhere in the country is assigned a justice, right? The justices are divided geographically, and they each have responsibility for roughly 1/9 of the country. The circuit justice for Wisconsin is Justice Amy Coney Barrett, for example, right? And the idea in the old days was that if you really needed emergency relief in the Supreme Court, you would go find the circuit justice. And the circuit justice by himself, because before 1980 it was always a him, the circuit justice would, often hold an oral argument on their own, sometimes in chambers. These were known as in-chambers arguments. Sometimes, in the case of Justice William O. Douglas, nowhere near his chambers. He was notorious for holding arguments in the Yakima courthouse during the summer when he was up in the woods in Washington State. And they would often write in-chambers opinions. So a one-justice opinion that says, hey, here's why I'm pausing the lower court ruling, or here's why I'm not pausing the lower court ruling. And that process had two major virtues. The first is that the circuit justices were very flexible. It was not hard, especially as phones became more ubiquitous, to track down a circuit justice and to get them to hear your application. And so you could often move very quickly when you just needed to find a single justice. And those circuit justices in turn could be flexible about holding arguments in chambers about writing opinions. But second, no one confused a circuit justice's brief one justice ruling for a ruling of the full court. Those rulings could not have had less of an impact outside of the immediate case, right, in which they were being handed down. And so it's not that there weren't important cases on emergency applications. It's that they tended to not have broader implications, right? How the Supreme Court handled an emergency application in one case tended not to affect the whole country. It tended not to even have statewide effects, right? And that was the way the emergency docket worked, really all the way into the 1980s. All right, so what changed? The short answer to what changed is the death penalty. So just another little brief moment of history. Some of you may remember that in 1972, the Supreme Court, by a 5-4 vote, issued what was effectively a nationwide moratorium on capital punishment. That case was called Furman versus Georgia. The court then flipped and brought capital punishment back 4 years later in 1976. But the death penalty that the Supreme Court brought back in 1976 was much more, for lack of a better word, judicialized, meaning there were a whole bunch more rules, right? If a state wanted to execute a defendant, it had to jump through a whole bunch more legal hoops. What that meant was that overnight, there were hundreds and hundreds of high-profile emergency applications from folks who were on death row all across the country, trying to block their executions on the ground that the state hadn't ticked all the boxes, that some legal claim hadn't been vindicated, that they had some right that the state had not observed. And those cases really put an extraordinary amount of pressure on the circuit justice model. because different justices had very different views about the death penalty. I mean, there was a world of difference between what, say, Justice William Rehnquist thought about the death penalty and what Thurgood Marshall thought about the death penalty. So very quietly, around 1980, the court starts treating emergency applications differently. It starts the practice of referring them to the full court if there's any chance two justices might disagree. This means overnight, we have a huge uptick in how many emergency applications are being resolved by the full court as opposed to by individual justices. But because it's the full court, the court also follows the norms that had developed when it voted to grant or deny certiorari, which is to say, no oral arguments, no explanations. And so the norm quickly became that even when the full court was ruling on an emergency application like a stay of execution, the ruling would be an unsigned, unexplained order. That really happens in the early 1980s. Why then, right, did no one notice? So I think there are two reasons why this shift largely went uncommented upon, unnoticed, unreflected on. The first is that I think there's a tendency, even among lawyers, to always take the attitude that death is different, that things happen in death penalty cases that aren't normal for any other sort of legal context. And so there's this mantra, death is different, that I think led folks to assume that was just this unique procedural accommodation the Supreme Court was following in those cases. But I think the second piece is, folks certainly have strong views about capital punishment, but those particular rulings, the Supreme Court allowing Texas to execute one prisoner or blocking Georgia from executing another prisoner, really didn't tend to have statewide and certainly not nationwide legal ramifications. Right? That the fact that the court had blocked or unblocked an execution might have been news, but it wasn't something that produced a ton of real world effects. And so, you ask people who clerked on the Supreme Court in the 1980s, 90s, and 2000s about the emergency docket, and they'll say it was all death penalty cases. Right? What we're seeing now is actually a trend that really started about 10 years ago. So around about 10 years ago, we saw the court starting to be asked and agreeing to issue emergency relief in contexts far afield of the death penalty, in contexts that really were about statewide or nationwide policies. The first really visible example of this was in February 2016, when the Supreme Court blocked President Obama's Clean Power Plan through an unsigned, unexplained emergency application. Ironically enough, that was Justice Scalia's last vote on the court before he died. During the first Trump administration, so starting in 2017, we saw the court issue emergency relief over and over again, especially to put President Trump's immigration policies that lower courts had blocked back into effect. During COVID, we saw the court use emergency applications and not the full sort of 9 yards of the merits docket to block a wide array of state and federal COVID mitigation measures. And in 2022, we saw the court use the shadow docket to allow Alabama and Louisiana to use U.S. House district maps that district courts had held, and the Supreme Court would later agree violated the Voting Rights Act. Indeed, you can draw a straight line from the Supreme Court's rulings on emergency applications in those cases to Republican victories in at least 5 House seats in the 2022 midterms. House seats that, if the Supreme Court had not intervened, would have been majority-minority districts, and chances are they would have returned Democrats. Just in case we don't remember, and why would we, the margin of Republican control in the 118th Congress that was elected in 2022 was 5 seats. And so the fact that Republicans controlled the House was directly traceable to unsigned, unexplained orders by the Supreme Court. All right. So that was already where we were. A couple years ago, Joan in her introduction mentioned my book. The book came out in May of 2023. And some of this behavior had already really been a problem. But what I want to suggest is that things have accelerated radically over the last 9 months in ways that are, I think, even more crisis causing than where we already were a couple of years ago. So let's talk about what's happened since January. Um, as of this morning, President Trump has filed a total since January of 30 emergency applications. Just to put that number into context, right? That's in 9 months. President Biden filed a total of 19 during his 4 years in office. Even first term President Trump, who broke every record in this, filed 41 in 4 years. And just to give you a sense of how extraordinary that was, his two immediate predecessors, Presidents Obama and George W. Bush, two slightly different two-term presidencies. Across 16 years, the Department of Justice filed 8. So we've gone from one emergency application every other year to one every 9 or 10 days. That is a radical increase in these cases. It's a radical increase in how much pressure this is putting on the court. And I suspect you guys already know this piece of this. As of this morning, the court has granted 23 consecutive requests for President Trump. Right, the 3 are still pending, and I'll talk about those in a bit. But these applications have been wildly successful for President Trump in ways that have, in almost every case, divided the justices ideologically. Right, where if there's a dissent, it's from the Democratic appointees, increasingly from all 3 of them. These rulings have had massive real-world impacts. Everything from allowing the president to cancel $4 billion in foreign aid spending that Congress had mandated, to kicking every single transgender service member out of the military, to subjecting hundreds of thousands of migrants who were here, if not lawfully, at least in a temporary protected status, to immediate arrest, detention, and removal, to firing tens of thousands of probationary federal employees, to firing even more sort of permanent employees through the civil service, to removing agency officials, you name it. I mean, the court has greenlit all kinds of stuff. All right, so what? Right? I mean, like, hey, a 6-3 Supreme Court with a conservative majority is regularly siding with Donald Trump. Why is that news? So what I want to suggest is that there actually are some pretty serious institutional problems with the Supreme Court's behavior that has nothing to do with the results in these cases, right? That my critiques are that the court is basically trampling on fundamental principles of how the court should be behaving without regard to whether they're getting the law right or wrong. So here are some of the things that I think are wrong. First, these interventions are producing massive effects, but without meaningful explanations. And I'm going to come back, by the way, to each of these. I'm going to list them first, and then we'll walk through them. So the court is, in almost all of these cases, not writing. Across the 23 grants of emergency relief to President Trump, the court has written 3 majority opinions. 2 of those were shorter than the length of an op-ed, right? And many of them are coming with no explanation whatsoever. And yet, it's still expecting everyone to sort of follow them. These rulings are having such broad impacts. That's a problem unto itself. Problem number 2, this is going to be a little technical, and I'm going to take a minute to try to explain it. But the court is justifying, when it's writing, the grants of emergency relief on the basis that every time a federal district judge blocks something that President Trump is doing, the government is irreparably harmed. Not just harmed, but irreparably harmed. That's important because that puts a heavy thumb on the scale in favor of the Supreme Court intervening. If the government's irreparably harmed, that seems like, well, then we should step in now and save them. As I'm going to explain in a minute, that is predicated on a total fiction that the Supreme Court has never really explained. Third, right, refusing to balance the equities. So even if the government's harmed, when a court is asked to grant emergency relief, it's supposed to look at which result will harm which side more, right? So the idea is that even if a stay, right, would harm one party, if not granting a stay would produce much, much, much more harm, then maybe you should grant the stay, right? That basically we should be balancing the harms caused by either our intervention or our non-intervention. The court is not doing that in Trump cases, even as it's continuing to do it in non-Trump cases. And that brings me to 4. The court is being wildly inconsistent. It's doing things in the Trump cases that it's not doing in non-Trump cases right now, and that it didn't do in Biden cases, right? So the deference that it's showing to the Trump administration that it didn't show to the Biden administration. All right, all of that would be bad enough. But the real crisis, and I think the reason why I'm not shy about calling this a crisis, is the last point. The justices are now insisting that their unsigned and usually unexplained orders are precedents that lower courts must follow in other cases, and they're even chastising lower courts for having the temerity to not follow these unsigned, unexplained orders in cases in which it's not clear why they should. All right, so I'm going to walk briefly through the evidence, right, for all 5 of these. So let's start with point number 1. Here is a typical example of one of these orders. I hope you guys can all see this on your screen. I'm not going to read the whole thing, but this isn't a case called McMahon versus New York. This is a case about the effort to basically, the neutral term would be downsize. I think the better term is kneecap the Department of Education. A district court had blocked the Trump administration's efforts to basically cut the Department of Education in half. The federal appeals court, the First Circuit in Boston, had refused to freeze that decision pending appeal. This is every single word the Supreme Court majority wrote in putting that decision on hold and in allowing President Trump to kneecap the Department of Education. And it's all boilerplate. There's no analysis. The court is just explaining that it is granting an application. It's explaining what order it is staying, and it's saying, and the stay will remain in effect until this thing happens. No analysis whatsoever. Now, I've cut off, there's a long dissent by Justices Sotomayor, Kagan, and Jackson, and that's not pictured. But this is all the majority wrote in this case. That is wild, right? Part of why it's wild is because in this case particularly, the Trump administration had offered 3 different independent arguments for why it thought the Supreme Court should grant a stay, for why it thought it was going to win. If you don't know which of the 3 arguments the court relied upon, what is a lower court to do in this case going forward, or in other cases going forward? Like, is it because these were the wrong plaintiffs? Is it because they filed in the wrong court? Is it because what President Trump did was actually legal? Nobody outside of the 9 justices knows. That's a huge problem, right? Okay, and then even as these are not being explained, we're seeing the Democratic appointees dissent more. So that's problem number 1. Problem number 2, harm. The Justice Kagan, I think, pointed this out very powerfully in one of her dissenting opinions. But basically, what's doing a lot of the legal, the analytical work in these cases is this idea that the government suffers irreparable harm whenever its policies are blocked. So if you actually reverse engineer where this idea comes from, and I'm embarrassed to admit I did, right? It has its origins in a series of in-chambers opinions, back when those were a thing, by then Justice Rehnquist in the late 1970s. Why is that important? Because Rehnquist was writing about something called the presumption of constitutionality. All right. The presumption of constitutionality is the idea that all things being equal, a statute comes to court with a presumption that it's valid, right? That the burden's on someone challenging a statute to show it's unconstitutional. And so Rehnquist says, right, a district court order blocking a statute irreparably harms the government. Rehnquist never said that the same is true of a district court order blocking an executive order. Right? Executive orders are not entitled to the presumption of constitutionality. Even worse, in a number of the Trump cases, the underlying claim is not just that it's an executive order, it's that the president is violating a statute Right? In the cases where President Trump has purported to fire members of the National Labor Relations Board, the Federal Trade Commission, the Merit Systems Protection Board, he's doing so in direct violation of statutes. Now, he claims those statutes are unconstitutional. Maybe the court agrees. But the notion that the executive is irreparably harmed by a district court decision that enforces a statute turns that presumption entirely on its head. And again, because the court is not writing in most of these cases, it has never had to reconcile this problem. It has never had to actually explain how this logic could possibly follow. Okay, problem number 3. This is, again, still a little bit nerdy in the legal weeds, but when we balance the equities, we really are supposed to ask which ruling will have more harm, right? If we block this thing, are we going to harm people? If we don't block it, are we going to harm people? Well, ever since COVID, and this is a quote from the OSHA vaccination case in January 2022, the court has taken the, if you'll forgive me, completely nonsensical position that it can't balance the equities. Right? So in the OSHA case, you have this remarkable passage in the very short unsigned majority opinion where the court says, hey, if we block OSHA's mandate, the businesses tell us they're going to lose tons of money. If we don't block it, the federal government tells us people are going to die. Historically, the court's job was to figure out which harm was worse. And yet here the court says it is not our role to weigh such trade-offs. So I realize that this is a bit of a nerdy legal point, but actually that's exactly what emergency relief is. It is weighing the trade-offs. When you don't weigh the trade-offs, all you're doing is asking who's likely to win. And against that backdrop, no surprise, right, that 6 Republican appointees are so often voting for President Trump. Okay, problem number 4, this is the inconsistency point. In non-Trump cases, the court is still doing the stuff it's supposed to do. And by the way, if you can see my video window right now, I have a friend with me. My 7-year-old has entered the chat. So in the non-Trump cases, the court is still doing what it's supposed to do. So there are 2 high-profile recent examples where the court denied emergency relief, even though it said the parties were likely to win on the merits, because it said, oh, but the equities don't support it. So in non-Trump cases, the equities are doing a lot of work. In Trump cases, they're doing no work at all. That's inconsistent in the abstract. It gets worse when we compare it to the Biden administration, right? So some of the court's defenders have said those cases don't involve the federal government, right? And so if we look at the federal government, that's a different standard. Well, no, it's not, because during the Biden administration, the court did the same thing. There are a couple of really high-profile examples where the court denied emergency applications from the Biden administration, but then ruled for it on the merits. Right, where it didn't show anywhere near the same kind of deference to the executive branch that it seems to be showing in these cases. All right, all of that would be bad enough, and then there's the precedent problem. On the left of your screen is an order the court entered on July 23rd, where for the very first time ever, the court said sometimes our unsigned, unexplained orders are precedential. Specifically, although our interim orders are not conclusive as to the merits, they inform how a court should exercise its equitable discretion in like cases. So Law School 101 for a second. Whether case B is like case A is often the entire question, right? The court's job is to figure out whether case B follows from case A. When the Supreme Court hasn't told you why it ruled the way it did, there's no way for the lower courts to know. So here you have the Supreme Court saying these are precedents. On the right, you have Justice Gorsuch chastising district courts in 3 different cases for not following precedents. Indeed, in a separate passage in this opinion, he accuses those district courts of defying the Supreme Court. That is a heavy charge for a Supreme Court justice to lob at lower courts, especially, guys, when the 3 cases Gorsuch claims lower courts defied, one of them had a 400-word majority opinion. One of them had no majority opinion and only 2 sentences of explanation. One of them had no explanation whatsoever. And that opinion was joined in full by Justice Brett Kavanaugh. So what I want to suggest is that this opinion, right, the opinion on the right side of your screen, the NIH ruling from August, really touched a nerve in the lower federal courts. And so right after that ruling, we started to see an unprecedented degree of loud public complaints by lower court judges, not about the Supreme Court's decisions, but about its behavior. This is a story in the New York Times on October 11th. And quoting from the Times, in interviews, federal judges called the Supreme Court's emergency orders mystical, overly blunt, incredibly demoralizing and troubling, and a slap in the face of the district courts. One judge compared their district's current relationship with the Supreme Court to a war zone. Another said the courts were in the midst of a judicial crisis. Hey, that would be a good title for a lecture series. Right? Well, this is not what we are used to hearing from lower federal court judges. You can find a comparable story from different judges reported by NBC in mid-September. And so we really are seeing a bit of a war between lower court judges and the Supreme Court. But it's not just between lower court judges and the Supreme Court, it's also within the Supreme Court. We're seeing increasingly sharp dissents from the three Democratic appointees. Justice Sotomayor, in a case about removing immigrants to third countries, said today's order clarifies only one thing. Other litigants must follow the rules, but the administration has the Supreme Court on speed dial. Justice Jackson, who I think is quickly earning her reputation for being the sharpest critic on the court, in that NIH case, the case with the Gorsuch opinion, wrote, "This is Calvin Ball jurisprudence with a twist." Calvin Ball has only one rule. There are no fixed rules. We seem to have two, that one, and this administration always wins. So if you stopped there, right, you would have a very, very sharp critique of the Supreme Court that it was basically reflexively or knee-jerkily siding with the Trump administration. But there's one outlier, and the outlier is a really interesting case. Back in April, you guys might recall that very, very late on a Friday night, the Supreme Court intervened. Good night, Sid. That the Supreme Court intervened to prevent President Trump from removing dozens of migrants from the Northern District of Texas under a statute called the Alien Enemies Act. And this was really extraordinary. It was the first time the court had really ruled aggressively against President Trump. The only public dissents were from Justices Thomas and Alito, suggesting that maybe there were as many as 7 votes against President Trump. And so a lot of folks hailed this as, oh, the court's finally waking up to the challenges and threats posed by the Trump administration. And indeed, the court backed up its brief order, the one that's on your screen right now, with a full opinion a couple of weeks later. The problem is, right, why was this case different? And so what I want to suggest is, well, 12 days earlier, so on April 7th, the court had held in another case about the Alien Enemies Act, a case called JGG, that alleged alien enemies were entitled to notice and pre-removal review. So the Supreme Court just 12 days earlier had said, hey, President Trump, before you do anything with folks who you claim are alien enemies, right, you should be giving them notice and an opportunity to be heard. Okay. Let me back up a second. In the AARP case, by the way, a totally bizarre coincidence. It was just the initials of the plaintiff. It was not the organization with which I suspect some of you are familiar. Right. But in the AARP case, the Trump administration had not followed the Supreme Court's directions. It had not given those guys notice. It had not given them a chance to challenge their removal. And so the court pushed back when what was at stake was its mandate, was its supremacy, as opposed to lower courts, right? So the Supreme Court was quick to defend itself against the Trump administration, even as it has not defended district courts. Indeed, even as it has in some of these cases, thrown district courts under the bus. Okay, what do we do with that? Well, if that's what explains the court's behavior, then my own view is that the real crisis here is what that will mean in both the short term and the long term for the relationship between the entire federal courts and the executive branch. In the short term, right, we're seeing rulings from the court that are further enabling and empowering an energetic executive. Guys, take the court's ruling in September in the Los Angeles ICE raids case. I don't think it's a coincidence that shortly after the court greenlit the ICE raids in and around Southern California, we saw ever more aggressive ICE raids elsewhere, including in Chicago and other cities. So the rulings are empowering an energetic executive at the expense of Congress. Again, the court is not enforcing these statutes at the expense of lower courts, who the court keeps throwing under the bus, right? Which only increases both the odds of future confrontations between the president and the courts and the stakes, right? And the sort of the drama that will likely ensue when those confrontations take place. In the long term, and this is, I think, the more subtle point, and it's the one that I want to spend the last couple of minutes on before we throw it open to Q&A. In the long term, the real problem is how much the court's behavior is continuing to erode public confidence in the courts as an institution. And this is happening in two respects. So folks who are already skeptical of this court, folks who are skeptical of this administration, look at the Supreme Court greenlighting more and more stuff by President Trump and not defending itself and not explaining why, and have even less faith in the court. But also there's the Stephen Miller part of this conversation, which is Stephen Miller keeps accusing every single lower federal court judge who dares to rule against President Trump of being part of what he calls a judicial insurrection. When the U.S. Supreme Court is itself chastising lower courts, wrongly in my view, right, for defying its rulings, that only adds fuel to that fire. Right. And so I think, that's the sort of the long-term cost, is that if and when you have that confrontation, the Supreme Court and the lower courts will be much weaker. Why? Like, how is that? How do you make that case? So this is the last piece of my presentation. So historically, the Supreme Court's power has been understood, and I think correctly, as soft power. Right? The court cannot enforce its own mandates. It has a police force, but the police force is not designed to enforce decisions. It's designed to protect the justices. Indeed, the court's rules, this is a bizarre but I think important point, literally provide that its mandates issue in the name of the president. This is Rule 45.1 of the Supreme Court's rules that are on the screen right now. Says all process of this court issues in the name of the president. Why? Because historically, it's the president who enforces the Supreme Court's decisions. How do presidents enforce the Supreme Court's decisions? Well, sometimes, as in the case of Little Rock in 1957, they send troops. So here you see the Army physically desegregating Central High School in Little Rock at the direction of President Eisenhower. Sometimes presidents enforce the mandates by complying with them. President Nixon in 1974 complied with the Supreme Court ruling, ordering him to turn over the Watergate tapes. One of the tapes he turned over was the so-called smoking gun tape, and it was the release of that tape, right, that really led to his immediate downfall and resignation. Why did they do that? Why did Eisenhower send troops? Why did Nixon turn over the tapes? The answer, right, is because historically, and at both of those moments, the Supreme Court enjoyed broad, diffuse public support. Not that we always agreed with the court's principles, but that we agreed that the court had principles. And so the court had a mandate. The court had the power to issue rulings like that because non-compliance with the Supreme Court was a political non-starter. Right, that Eisenhower would have faced dramatic political repercussions if he had not enforced Brown. Nixon would surely have not just been impeached, but convicted by the Senate if he had not turned over the tapes. And that was how this worked historically. But the more energetic and the more powerful the executive becomes, and the more the Supreme Court's own behavior contributes to an erosion of public faith in the judiciary as an institution, the less likely it will be that that support will exist if and when the court really needs it. Well, when might the court need it? Oh yeah, that guy. Right? For the very real possibility that President Trump will not follow an adverse ruling, whether it's in the tariffs case, which is set to be argued next week, whether it's in the birthright citizenship cases that are coming back later this term, whether it's in the currently pending emergency application over whether he's allowed to federalize National Guard troops and send them into Chicago. And so the Supreme Court is walking quite a tightrope and is playing a very dangerous game when it is acting in the way it's been acting over the last 9 months. Okay, before we turn to Q&A, I have some good news. And I don't want to sort of make this presentation all just depressing and a downer. The good news is that I actually don't think it's that hard or that implausible for the Supreme Court to actually fix a lot of these problematic behaviors. Right? The problem is not the existence of the shadow docket. It's how the court has used it. And so it would not be hard for the majority, even if it's going to keep ruling the way it's ruling, to provide at least a modicum of explanation in any case in which it grants emergency relief to establish legal principles, both for the benefit of lower courts and the public, and so that in future cases, the court will have to follow those neutral principles. To commit to actually identifying and then faithfully applying the right standards. So actually like explain why there's harm, explain why the balance of the equities supports President Trump over, say, the entire Department of Education. Recommit to the usually well-established principle that orders without reasoned opinions don't and shouldn't have precedential effects. And if there's problematic behavior in the lower courts that the court wants to curb, tell them. Like, crazy idea. If you think lower courts are behaving badly, you have the ability to explain what they're doing wrong. I realize that that's a bizarre thing to suggest in 2025. Okay, it is possible, of course, that a court that behaves better in these respects will still hand down plenty of decisions with which we disagree. It might even be inevitable, so long as the court it remains as it is currently constituted. But at least then, the Supreme Court would be articulating neutral principles that would apply to future presidents, regardless of their party. It's possible, if not likely, that in many of these cases, having to provide a full-throated explanation would, if not lead to a different outcome, at least temper the conduct that the court is authorized. And if the court had to write, it might actually articulate principles that would constrain the executive branch, as we're seeing in the lower courts right now. Either way, right, the judicial crisis in which the Supreme Court is not providing guidance to lower courts and is yelling at them anyway, would abate. And we would actually, I think, see the system working, for better or for worse, more along the lines that it was historically intended to. It wouldn't solve the other separation of powers crises that we're currently confronting, but it would at least, I think, put the courts back on the right track. All right, last couple of points. So first, why should you care? Right, you probably were not expecting a long discourse on appellate procedure on a Tuesday night in October. So I think it's pretty clear by now that this is not just a wonky debate about a technical part of the Supreme Court's docket. It's about the extent to which the Supreme Court's power depends upon its ability to explain its rulings. The point is not that we're always going to agree about or with the legal principles the court's espousing. It's that we'll hopefully at least agree that it's espousing principles. And that's why, as part of her book tour, Justice Barrett, I was actually at an event of hers this afternoon, is urging all Americans, but especially the court's critics, to read the opinions before judging and criticizing the court. And yet more and more, the court is handing down rulings with unprecedented impacts in which there's no opinion to read. Right? That seems to be a problem that we can fix, and a problem that is a problem until it's fixed. Why? So here's Justice Jackson in the NIH case back in August. She says, this court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law as they interpret it will surely hasten the downfall of our governing institutions, enabling our collective demise. She's very cheery. Right? Well, I want to end with a different Justice Jackson, with Robert Jackson, who wrote one of the most important separation of powers opinions in the Supreme Court's history in the Steele seizure case in 1952. Jackson, who had been the Solicitor General under FDR, who had been Attorney General under FDR, who had represented the United States at the Nuremberg war crimes trials, where he had seen firsthand the dangers of a legal system that stops standing up to the executive, closed his critically important opinion with these words. He says, with all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of the court to be last, not first, to give them up. That was Justice Jackson in 1952. I think it's a really important point to end on. And it's also why I'm spending so much of my time these days writing the newsletter that Joan mentioned, which you can find either at that website or by scanning that QR code. I'll leave this up for a couple minutes, but Brandy, I'm also happy to turn this over to you for questions.
Yeah, absolutely. Thank you so much for that wonderful presentation. I'm sure that we could spend hours talking about this. So thank you for condensing it for us. Again, if you popped in a few minutes late, feel free to put your questions in the chat. You are also welcome to raise your hand if you prefer to ask your own. I am actually going to turn it over to Sinceri Dixon to facilitate the Q&A, and then we will wrap up with Joan.
Hi, everyone. I'm Sinceri. I'm the communications manager with the league. Thank you all for being here. I'm going to scroll back through the chat to go back to the first question that I saw this evening was from Christy Schwan. She asks, what, if any of this, is being orchestrated through behind the scenes manipulation by the authors of Project 2025?
Um, so I think there's not that much that's happening at the US Supreme Court that is being orchestrated by anyone outside the Supreme Court. I think the justices, for better or for worse, and I would say probably for worse, don't need help. Right? It is a fact, one that I think is unfortunate, but also undeniable, that we have a court at this particular moment in our history that is more supportive and solicitous of broad theories of executive power, that is more suspicious of Congress than any of its predecessors. And that would have been true no matter what President Trump was doing. Indeed, I think it would have been true no matter who the president was, as long as they were a Republican. I don't know that they need that much help from Project 2025. I think the larger issue is that the court is sort of it's not just like issuing merits rulings for President Trump. Like that would be a problem unto itself if the court were passing on the legality of the tariffs or the legality of the birthright citizenship executive order or the legality of what ICE is doing. And the problem with these emergency applications is that the court is not actually saying that Trump is doing anything legal or illegal. It's just saying you can keep doing this for now. And that's, I think the justices are telling themselves a story that they are, these are interim rulings, they're temporary rulings, they're not committing themselves to a view on the merits. And I think that's stunningly naive, right? That the rulings are producing so much harm, both to real people out in the world and to long settled separation of powers principles, that, what the justices might think of as a play for time is actually, I think, a deeply, deeply coercive set of rulings that really, I think, are reinforcing Project 2025, even without necessarily saying that any of its planks are actually valid. So that's how I think that cashes out.
Great. Thank you so much. And the next question comes from Dorothy Sky. She asked, what short-term and long-term strategies should we citizens pursue to achieve fixes of the shadow docket?
It's such a good question. So I guess what I would say is two things. The first is I think that the shadow docket is actually a symptom of a broader disease, that if we really peel the layers of the onion back, the real issue with the Supreme Court that we have today is that the court is not accountable to the other branches to a degree that we've never seen before. Justice Alito gave a remarkable quote to the Wall Street Journal in the summer of 2023. He said, and it's so remarkable, I've actually memorized it. Well, you already knew I was a nerd. We've been together for an hour. But so the quote is something to the effect of, I realize this is a controversial position, but I'm willing to say it, which is always a good way to start a quote. He says, no provision in the Constitution gives Congress the power to regulate the Supreme Court, period. That was Alito. The period is what makes it art. So Alito is literally wrong. I mean, Article 3, Section 2 literally gives Congress the power to regulate the Supreme Court's appellate jurisdiction, to control the court's docket. But he's picking up on, I think, a point that has been true in practice, which is that Congress has stopped nudging the court, that the court doesn't have to look over its shoulder. Right? Why does Justice Thomas or Justice Alito not pay any price for their, I think, ethical troubles and misbehavior, where Abe Fortas in 1969 had to resign? It's because in 1969, the court was worried about Congress, and today it's not. And so the long-term solution to me, right, is really to get the court back to a place where it's looking over its shoulder. The court is healthiest historically when it is at least somewhat accountable, right, to the elected branches of government, when it's not just doing whatever it wants whenever it wants. My friend Leah Littman, who some of you may know, who is the co-host of the Strict Scrutiny podcast and just wrote a book called Lawless, right, she says it's no law, just vibes. Or the YOLO court, you only live once. Well, there's a lot to commend that, the way the court's behaving. So that's the long-term answer. In the short term, honestly, I think people like us should be talking about this. And this is part of why I was so delighted when Joan reached out to me, because you guys are my dream audience. You are interested, right? You are engaged, and you just maybe need a little bit of sort of nudging from a nerd like me to figure out what you should go and be telling people about what the Supreme Court is doing wrong. And I think we make a mistake when we pitch debates about the Supreme Court in terms of rulings we don't like or justices we don't like, because that just sorts everyone into their camps, right? To me, the way we make a dent is by talking about the Supreme Court's behavior on an institutional level and why it is completely insane. There is not a normative defense of treating unsigned, unexplained orders as precedents that district courts are defying by not following. That's not a conservative liberal thing. That's just what we call nuts. Right? And so when we have these kinds of institutional conversations about the court, when we tell our friends, can you believe the court is not telling us why it's ruling? Shouldn't it be telling us why it's ruling? Even our friends who might be sympathetic to President Trump, if you still have any, right? Wouldn't you like it for the court to tell us why? Right? That's this is where we should be focusing our efforts, changing the conversation. And I'll just give you guys one, and this is a bit self-indulgent, and I apologize, but one example of this is the term shadow docket. Right? That term bothers the hell out of most of the Republican appointees. They hate it. They're trying really hard to rebrand because they really don't like the term. Why has the term caught on? Why has it stuck? So I think I can claim a little bit of credit for it, right? Because of the book, but it's caught on because it's describing behavior, not decisions, right? Because it's describing an institution that is running amok, not a methodological approach to constitutional interpretation that we either do or don't like. And so in the short term, we've got to change how we're talking about the Supreme Court. In the long term, we've got to, have a Congress that actually believes that part of its job is holding the other branches, both of them, institutionally accountable. And that's a very long answer to a very good and short question.
Thank you. I appreciate your thoroughness. Susan Olson is asking, would expansion of the court have any impact, if at all, on these functional behaviors we currently struggle under?
So, maybe, it depends on who you're expanding the court with. I will just say I am not a big fan of court expansion, for two reasons. Right. The first is I really do think that it will set off a race to the bottom, right? That like if the Democrats have a trifecta in 2029, heaven forbid, and we're able to, sort of add 4 seats to the court. Well, the next time the Republicans have a trifecta, they'll add 8 seats. And then it'll be just sort of, how many seats can you add at once? So that in 40 years, the Supreme Court will have 75 justices and no credibility because everyone will understand it's whoever had power last that controls the Supreme Court. And from my perspective, guys, I am a judicial supremacist. I want the court to be healthy. I think our system depends upon a responsible, healthy Supreme Court. And I think court packing would actually undermine that. And then in the short term, I also just think that like there's no reason to believe that if you had a Democratic supermajority on the court, you wouldn't see bad procedural behavior in the other direction. Right now, maybe we'd be okay with that because the results would be results that we liked. But, I really do think that from an institutional perspective, that's, the wrong solution to the problem.
Thank you. So Janie has asked 2 different questions that I'm going to kind of combine. She says, can the people have any influence over the Supreme Court and how? As well as how are we going to get past the Supreme Court ruling that the president is above the law?
So I think to the first part, the Supreme Court, despite what they will try to tell you, is deeply subject to social movements. And the way that, I can give you lots of evidence. Let me give you the latest, stupidest example. So you guys might recall that a couple of years back, the justices adopted this code of conduct for their behavior. Now, listen, to call the code of conduct a half measure is to do grave injustice to half measures everywhere. It was, a completely toothless thing. And yet, the fact that within 7 months of ProPublica's first reporting on Justices Thomas and Alito, the Supreme Court, the slowest, most conservative institution in government, felt impelled to do even that was a remarkable, I thought, concession to public pressure. Not that they did the right thing, but that they did a thing. Right? And it was, I think, actually missed at the time just how much that proved that concerted, organized, institutional pushback against the court will resonate inside that building. The same, I think, can be said to some degree about the shadow docket. Before Trump came back to office in January, we actually really had seen some moderation of the court's behavior on emergency applications. And a lot of that was because I think Justice Barrett, for example, had come around a bit on some of the institutionalist critiques of emergency applications. That has faded over the last 9 months because Trump. But I think there's lots of evidence of the ability of people, right, to really affect the court. On the immunity ruling, so let me say, I think it's worth not overstating that disastrous ruling. Right, the ruling holds that the president can't be criminally prosecuted. It doesn't say he's above the law. The best example of that is that there have been somewhere north of 160 district court rulings since January blocking different actions or policies from the Trump administration. We've spent a lot of time tonight talking about the Supreme Court and how the Supreme Court has greenlit 23 of the Trump administration's actions. Guys, 23 out of 160 is still a pretty small percentage. It's not a math quiz, so I won't ask for what the percentage is. But right, the courts are actually holding the president accountable in lots of ways. And listen, there have been a couple of high-profile examples of this administration not following lower court rulings. But guys, those have been the exception. The typical adverse ruling against Trump is being followed by the executive branch and is either not being appealed or is being appealed in the slowest, least we think we're going to win way possible. And so, for as down as we might be on the Supreme Court, and listen, I'm pretty down. I write a newsletter about them twice a week, and each time I do it, I get mad. Right? We shouldn't therefore equate this administration with complete lawlessness, right? It might want to be lawless, but actually I think the lower courts have been over and over again the most effective check on this administration over the first 9 months. Not enough, but more than anybody else.
Thank you. So we have a historical question from Kathleen. She says, how did the Supreme Court regain its influence after Andrew Jackson refused to enforce the Supreme Court ruling about Cherokee lands?
Um, all right, I'm really sorry to burst your bubble, but that story is apocryphal. I wish I had better news. So I'll put it in the chat because I actually wrote a whole issue of my newsletter about this quote. But the short version is, right, the quote, John Marshall has said the law, now let's see him try to enforce it, was allegedly about a case called Worcester versus Georgia. The problem is that if you actually look at what happened in Worcester versus Georgia, and I just put a link in the chat. Let me actually do one thing better. That has a paywall. Let me put in a link that does not have a paywall so that you don't have to pay to subscribe to the newsletter just to see it. Stand by. Okay. So in Worcester versus Georgia, the question was about the state of Georgia. The federal government was not a party. And so there was literally nothing Jackson could do to defy the Supreme Court in that case. The first appearance of that quote is in 1862 from Horace Greeley. And it's probably true that Jackson never said that. That said, I mean, let me take the question in a slightly different direction. The Supreme Court has done things that have drastically undermined public faith in the court. The Dred Scott ruling in 1857, right, was hugely damaging to the court's reputation. Bush versus Gore in our lifetimes, hugely damaging to the court's reputation. The way the court built its reputation back is that there weren't more of those in quick succession, right? That the court did not pile hugely controversial ruling on top of hugely controversial ruling on top of hugely controversial ruling. Versus in 2022, when the court handed down Bruen, the Second Amendment case, and Dobbs on back-to-back days. Right. And so, you really saw the court after Dred Scott, after Bush versus Gore, after some of its other controversial decisions historically, work hard to not sort of further undermine public confidence and work hard to look more, how do I say, humble and accountable in the years years immediately after. We're not seeing that today. And I think that's a big part of why we are where we are.
Thank you so much. So we have a question from Janie and Sarah that I'm going to kind of also put together just for the sake of time. So Janie was asking if the president defines rulings of the Supreme Court, then what happens? And Sarah asked, without checks and balances between the different branches of government, then what? Do we have any recourse?
Whew. Okay, those are two big questions. So the defiance question really depends on the context in which we see defiance. Right? If it's a one-off, then I think the question would be what political consequences, if any, would President Trump face? I'm about to say something that will probably provoke many of you guys to throw things at your screens, so please don't. Right? I still have like an iota of faith, not in congressional Republicans in general, but in 4 of them, because that's all it would take in each chamber. It would take 4 members of the House. It would take 4 senators to believe that defying the Supreme Court actually was a red line. There are plenty of red lines that have already been crossed, but I have faith that there's still a handful of folks who would see defiance as a real, even for Trump, a real sort of make or break moment. But I also think the administration knows that. So during the oral argument in CASA, the birthright citizenship cases back in May, there was this truly remarkable exchange between the Solicitor General John Sauer and Justice Barrett, where Barrett expressed real exasperation that she thought Sauer was suggesting that they would not be bound to follow a ruling striking down the birthright citizenship executive order. And Sauer quickly clarified that what he was saying was that they wouldn't be bound by a out-of-circuit ruling, right? So if the federal appeals court in New York said something, they wouldn't have to follow it in Wisconsin, but that they absolutely would follow a Supreme Court decision on a nationwide basis. Now, striking that you even had to have the Solicitor General say that. There's no prior administration in which a justice would have even asked that question of the Solicitor General. But I also think it's striking that Sauer believed he had to answer that way, that he had to tell the court that they would follow. And that's memorialized in Barrett's opinion. And so I think actually the administration knows that it can sort of nudge the court, it can sort of cajole the court, but it actually doesn't have the political capital to defy the court. To the checks and balances question, I mean, this is such a good question. I will just say two things. The first is we are getting an object lesson on a daily basis in two features of our constitutional system. One is the importance of Congress and what happens when Congress disappears, literally and figuratively. Right. And, Madison wrote in Federalist 51 that ambition is supposed to be made to counteract ambition. We have an ambitious executive. We have an ambitious judiciary. We do not have an ambitious Congress. We're seeing the consequences. But guys, two, there's another check, and the other check is states. Right? Federalism is actually supposed to be a really important check. And especially in a state like Wisconsin, I think you guys live that on a daily basis. In ways that folks in states that are either deeper blue or deeper red don't. Right? Where states that have real political power actually have the ability to exert at least some force. Look at the litigation challenging President Trump's federalization of National Guard troops. Who are the plaintiffs in those cases? The plaintiffs are states, right? It was Governor Newsom in the California case. It was the state of Oregon in the Portland case. It's the state of Illinois in the Chicago case. That's, I think, an important point that states actually are also capable of protecting us. We run even our federal elections through states. Part of why President Trump is complaining so much about the rules for elections is because he can't change them. Only states can. That's not to say that there won't be some mischief in some states in the run up to next year and in 2028. But, imagine how different things would be right now if the federal government controlled federal elections. We're very lucky that they don't. And so, don't sleep on how all of these checks, even though they're not supposed to be the only ones, are still actually doing a lot of work. Indeed, guys, while we've been chatting, the Ninth Circuit, the Federal Appeals Court in San Francisco, has actually agreed to wipe away the panel decision from last week in the Oregon case. Right, so there had been a bad panel ruling last week that had frozen the district court decision in the Portland National Guard case. The full Ninth Circuit has now wiped that away. So again, there are positive signs of checks. And even if Congress sucks, and I think we can all agree Congress sucks, right? That is bad. It is producing tons of pretty bad results. It is not the end of the story. There are other guardrails, and many of those guardrails are actually still working.
Perfect. Thank you so much. So we will take about 2 or 3 more questions just to give kind of a general idea of how much time we have left. So CJ has said, Justice Roberts used to have a strong sense of history and how the court is viewed by the body politic. Do you have a sense of why he now seems to be siding with the runaway train MAGA wing of the Supreme Court in terms of procedure with these unexplained orders?
I sure wish I did. I wrote a post. Let me see if I can find it. I wrote a post a couple weeks ago because we had the 20th anniversary of the Roberts Court. And it was really quite striking to compare some of the things Roberts had said in his confirmation hearings back in 2005 and in his early decisions with his behavior lately. So I just put a link to that post in the chat. I think two things are happening, right? The first is I think Roberts is and always has been a bit more of an executive power zealot than maybe we've appreciated. And you can find sort of symptoms of that in pre-Trump cases, but that it's really come to the fore in these cases. But I think the second part is Roberts doesn't want a whole bunch of confrontations with Trump. And I don't think it's that bizarre, even though I think it's naive. I don't think it's that bizarre to view Roberts as thinking of himself as appeasing Trump. That the emergency applications, right, don't, how do I say, don't fully resolve the merits of these cases, that he's playing for time, that he's allowing Trump to do this stuff in the short term, but he's preserving his ability in the long term to rule against them. Um, but as I said, I think that's really naive. We'll see as early as next week. I mean, guys, the very, very first Trump case that the Supreme Court's considering on the merits on full review is being argued next Wednesday. That's the tariffs cases. Um, right. And so, I will be really interested to see whether Roberts and Barrett, especially, come out of the gates in those oral arguments hostile to the Trump administration or, more supportive than we might have expected. I think that's going to be a real tell. Because it is very possible that by the end of the court's current term next June, the court has ruled against Trump a bunch of times, and Roberts would have to be in the middle of that. When I handicap the current Supreme Court, obviously I know who the first three votes against President Trump would be. I'm fairly confident that the fourth is either Barrett or Roberts, and that the fifth is the other one, because Brett Kavanaugh might be the sixth vote against the Trump administration. He'll never be the fifth. That means that the Roberts question, which I don't have a fully good answer to, is really the question, because how he and Barrett go, I think, is going to say a lot about how the court goes from here.
Thank you. Joan would like to know, how much impact has the immunity decision had on the Supreme Court's allowing Trump so much latitude on the shadow docket?
Um, I think I don't think that there's a lot of direct impact. I mean, I think it is enabling bad behavior. I think it's emboldening the Trump administration. But I don't know that it's the immunity decision itself as opposed to the approach to executive power that it reflects. Right? That the real problem with the immunity decision is just how much it reveals all of the Republican appointees to be defenders of stunningly broad visions of executive power. And I think it's the sort of what caused the immunity decision is what is causing some of the mischief on the shadow docket. That, like, they have the same cause. I don't think that they're quite that. I don't think that one caused the other. They have the same underlying cause. That's what I'm trying to say.
Okay, thank you. And then we'll just wrap it up with one last question. Apologies for any questions that we didn't have time to get to. But Dorothy has asked, are any members of Congress creating legislation to fix the shadow docket?
The Dems are trying. I think the problem is that the real fixes are subtler and longer term. And so there are things you can do by statute. You can ratchet up the standard the court has to meet to grant emergency relief. You can limit the court's jurisdiction even, maybe. But the real changes, I think, have to come in broader, longer institutional terms. And so that kind of legislation is broader. That's Congress reclaiming the power it has over the court's budget. It's Congress reclaiming the power it has over the entirety of the court's docket. It's Congress, making life a little more difficult for the justices if they don't like what the court is doing. Like, there's a long history of that we've gotten away from. And let me just quickly tie together. A couple folks in the chat have asked about term limits. Right? I think term limits are fine. I don't know that the folks who are big proponents of term limits hold them out as something that would sort of take some of the heat out of the confirmation process. I really have a hard time just because we know there will be confirmations every 2 years, I think is not going to lower their stakes. I mean, you guys know you have presidential elections every 4 years. Does that make them less intense? Right? No. I think you could do term limits by statute. I think Congress could change what it means to be a Supreme Court justice by statute, but only prospectively. And so even if you had a public critical mass for term limits, they'd only be effective once all 9 of the current justices are gone. So it's a great reform in, 30 years. This is, I think, the larger point, right? Which is so many conversations about Supreme Court reform are focused on bright, shiny objects, term limits, or an ethics code, or expanding the court. And actually, what the court really, really, really needs is not bright, shiny objects, but a healthy kick in the butt. And the kick in the butt doesn't come through term limits or more justices or those kinds of things. It comes from Congress reclaiming power over the court that it exercised regularly all the way into the 1980s and then just stopped. Right. And that's obviously a harder sell politically, but it goes back to a point I made earlier, which is why when we talk about the Supreme Court, we should be talking about the court in these kinds of institutional terms. And it's why, so much of my work these days is trying to tell that particular story, whether in events like these or through the newsletter or elsewhere. So, that keep the ideas coming, but I really think that the reforms have to be this broader, subtler, restoration of the healthier interbranch dynamic that characterized our separation of powers really for the first 200 years of the Republic.
Thank you so much, Stephen. I am going to turn it over to Joan. I know she has a wrap up for us. I just want to remind you that I am going to drop the feedback questionnaire in the chat. Also, some of our attendees are wondering if you might be able to share the resources you shared. So I'm wondering if you might be willing to send those to me, Stephen, and I can distribute those.
Yeah, I mean, sure. I think everything I've posted tonight has been from my newsletter, and so I will send that link out around as well. I would just, the one quick word on the newsletter, right? About 2/3 of the content is free, and so even if you're wary about subscribing to another newsletter, most of what I put out you wouldn't have to pay for. So just a thought.
Awesome. Well, I'm going to turn it over to Joan, and from me and the staff and the board and all of our attendees, thanks for coming this evening.
Thank you.
Joan, I don't think you unmuted quite yet. There you go.
Thank you so much, Professor Vladek. Very, very comprehensive. I knew you were the right person for this discussion. I'd like to announce that following Professor Vladek's presentation on the shadow docket, the League's Impartial Justice Committee is presenting presentations on the impact of shadow docket orders on Wisconsinites. We'll be posting on the League's YouTube channel presentations. The first YouTube presentation is on the impact on Wisconsin students as a result of the Supreme Court shadow docket order about the massive cuts to the Department of Education. Our speaker for this YouTube presentation is Julie Underwood, the former Dean of the UW Department of Education. We are in the midst of planning additional YouTube presentations on the impact of farmers in Wisconsin, the farm economy, and communities as a result of the Supreme Court's shadow docket order to cut the USAID funding. And we're also planning a presentation on the impact on the University of Wisconsin as a result of the Supreme Court's shadow docket order to cut National Institute of Health and National Science Foundation grants and the impact these cuts have had on public health in Wisconsin. So please watch for these announcements about the YouTube presentations. I think you'll find them very interesting because we need to look at the real world consequences of these decisions on Wisconsin. Thank you.
Thanks, Joan. Thank you again, Stephen, and thanks to everyone who attended. Again, the recordings will be up on our website and made available on our YouTube page, and I'll let you guys go enjoy the rest of your evening. Thanks so much.
Thanks, Brandy. Thanks, everybody.
Thank you.